Tonight, we begin with a legislative development that immigration attorneys had feared, policy experts had predicted, and millions of green card holders had desperately hoped would never come. A law that unfolded not over years of debate, but in a single legislative session. A single session that rewrites the rules of permanent residency. A single session that affects over 13 million green card holders currently living in the United States. A single session that changes what it means to hold a green card starting in 2026. What Congress did today crossed a line that immigrant advocacy groups had hoped would hold. And when that line broke, affected communities did not hesitate. They responded with urgency, with coordination, and with a demand for answers. For 18 months now, there had been signals. Not official announcements, not formal press releases, just signals. That lawmakers were preparing something unprecedented. Congress has been aggressive on immigration reform, yes, but they have been methodical in their aggression. Their moves have followed a certain pattern, a rhythm, almost a predictability. But what set off alarm bells in Washington this week was that the pattern went silent. Immigration policy analysts who monitor Capitol Hill know the indicators. The sudden cancellation of scheduled hearings, the closed-door meetings between key committee chairs, the unusual bipartisan handshakes in hallways, the sudden disappearance of draft legislation from public tracking systems, all of that went quiet. And whenever Congress goes quiet on immigration, it means something is about to get loud. For weeks, immigration attorneys across the country had been fielding calls from nervous clients, green card holders who had built lives here, raised families here, contributed to communities here, all asking the same question. Should I be worried? The answer, we now know, is yes. Early this morning, the House Judiciary Committee released what they described as the Permanent Residency Accountability Act of 2025, including provisions that had not been discussed publicly in over a decade. These are the kinds of legislative changes that Congress only pursues when they are signaling something very specific. A fundamental shift in how America treats its permanent residents, a new era of enforcement, or a complete reimagining of the path to citizenship. Legal observers didn't know which category this fell into, or whether it fell into all three at once. But what they did know was that Congress was changing its posture on green card holders. And when the legislative branch shifts posture on immigration without explanation, even by small degrees, every immigration attorney in America pays attention. The bill, now officially passed through both chambers as of 4:47 p.m. Eastern Time today, introduces what lawmakers are calling enhanced verification protocols for all current green card holders. Starting January 1, 2026, every lawful permanent resident in the United States will be subject to new requirements that fundamentally alter the nature of permanent residency. The advisory issued by the American Immigration Lawyers Association tonight was not normal. It was not routine. It was not symbolic. It was urgent. Attorney after attorney, legal expert after legal expert, described Congress's move as unprecedented in scope, aggressive in timeline, and perhaps most importantly, retroactive in application, meaning it applies to green cards already issued. But legislative action only works if affected communities remain passive. Green card holders did not. In fact, their response today was among the most coordinated we've seen in modern immigration advocacy. Here's what we know. Within 3 hours of the bill's passage, the National Immigration Law Center filed an emergency petition challenging the constitutionality of retroactive application. These weren't routine legal challenges. These were constitutional challenges, legal mechanisms that advocacy groups only deploy when they are preparing to fight all the way to the Supreme Court. Immigrant rights organizations in all 50 states activated phone trees, hosted emergency town halls, and began coordinating what they're calling the largest immigrant response network since DACA. Tonight, multiple sources confirmed that the new law introduces mandatory re-verification requirements on all green card holders, including those who received their permanent residency decades ago and had assumed their status was, as the name implies, permanent. The law mandates the following before it could be challenged. They require biennial registration. They require proof of continuous physical presence. They require updated background checks every 24 months. They require employment verification tied to original visa category. In other words, Congress targeted the fundamental assumption of permanent residency, the permanence that made it meaningful. This is what made the legal community's warning so urgent. Congress's move wasn't just symbolic, it was operational. It represented the kind of legislative shift that could destabilize millions of lives if left unchallenged. And advocacy groups, understanding that fully, responded with force, not recklessly, not impulsively, but strategically. They didn't file frivolous motions designed to delay. They didn't issue empty threats to media outlets. They hit the constitutional arguments. They hit the procedural vulnerabilities. They targeted the provisions most likely to be struck down by federal courts. And here's where the story becomes even more significant. Legal analysts now believe that Congress's latest move was designed to test the resilience of immigrant communities after years of legislative uncertainty. Lawmakers wanted to see whether green card holders would accept these new conditions quietly. But instead, the opposite happened. Affected communities didn't retreat into fear. They mobilized with a speed that was so organized, so immediate, that even veteran congressional staffers noticed. You don't get Congress's attention easily. But today, green card holders did. Immigration policy experts speaking with major outlets under anonymity described Congress's shift as strategic overreach, a way to establish new baselines for what permanent residents will accept. But immigrant advocacy groups proved today that they remain both vigilant and prepared. Their legal filings were not only comprehensive, they were timed so precisely that the first injunction request landed on a federal judge's desk before the president's signature was dry. That timing matters because it shows strategic preparation. It shows that the immigrant rights community is not a passive recipient of policy. They are an active participant in shaping it. As reports continued coming in throughout the evening, we learned more about the scale of this law's impact. Employment-based green card holders face new requirements to prove ongoing employment in their original sponsorship category, forcing millions to obtain updated documentation from current employers. Family-based green card holders must now demonstrate continuous family relationships, including updated affidavits from sponsoring relatives. Diversity visa recipients operating under already precarious circumstances reportedly face the strictest verification requirements, with some provisions requiring proof of ongoing contribution to national interest. This wasn't just bureaucratic adjustment. This wasn't just administrative streamlining. This was fundamental restructuring. This was redefining permanence. And redefining permanence is the one thing immigration attorneys have warned against since comprehensive reform began. For every protection green card holders thought they had, Congress has now introduced conditions that complicate those protections. Remember, Congress thought green card holders would accept gradual erosion of rights. They thought affected communities lacked the resources to mount legal challenges. They thought the fragmented nature of immigrant populations would prevent unified response. But tonight, the exact opposite is happening. Unified legal coalitions are forming across all 50 states. Funding for legal defense is pouring in from unexpected sources. International attention is focusing on American immigration policy with renewed intensity. The assumption that permanent residents would remain passive has proven catastrophically wrong. What makes this moment so critical and so volatile is that Congress's latest move happened at a time when immigration policy is under unprecedented political pressure. Restrictionist factions want complete overhaul of all immigration categories. Business interests want protection for employment-based green card holders who power critical industries. Humanitarian organizations want preservation of family reunification principles. State governments want clarity on how to implement federal mandates. Congress is balancing these demands while approaching a contentious election cycle. And when legislators in that position make sudden moves, they're not doing it from strength. They're doing it from pressure. They're doing it from vulnerability. This law represents not confident governance, but reactive policymaking, an attempt to satisfy multiple constituencies while hoping affected communities remain silent. They will not remain silent. USCIS's statement, now circulating across all major news platforms, was designed to signal that the agency is prepared to implement these changes regardless of legal challenges. Officials said plainly that the new verification requirements were consistent with congressional authority over immigration matters. That is bureaucratic language for, "We're moving forward whether you like it or not." You don't usually hear that tone from USCIS unless something serious is at stake, and unless the agency has been given explicit political cover to take an aggressive posture. Meanwhile, the Department of Homeland Security released a supplementary memo outlining enforcement priorities for 2026, specifically mentioning verification compliance as a top-tier focus. This coordination between legislative and executive branches suggests advance planning that predates today's vote by months, if not years. Meanwhile, the executive director of the National Immigration Forum addressed affected communities in a direct, urgent address tonight. She said, "Today's law does not reflect American values. It reflects political calculation." She said, "Permanent means permanent. We will fight to ensure that promise is kept." And she said, "To every green card holder watching tonight, you are not alone. You have never been alone, and you will not face this alone." These are not rhetorical flourishes. These are statements from an organization that understands just how high the stakes have become. Similar statements emerged from the ACLU, the National Immigration Law Center, United We Dream, and dozens of regional advocacy organizations. The message was consistent: prepare, but do not panic. Organize, but do not despair. Here's what makes the situation even more concerning. Congress's latest move wasn't isolated. Along with the Permanent Residency Accountability Act, the State Department also announced enhanced scrutiny for consular processing of family-based petitions. ICE released updated enforcement guidelines expanding interior enforcement priorities. USCIS increased application fees for naturalization by 35%, effective immediately. All of this happened within the same 72-hour period. When Congress moves multiple pieces at once, it means something larger is underway. This isn't random policy adjustment. This is coordinated restructuring of the entire immigration framework, and green card holders are at the center of it. Legal analysts are now considering several possibilities. One is that Congress is preparing for comprehensive immigration reform and using this law as a negotiating baseline. Another is that lawmakers are attempting to reduce the green card holder population through administrative attrition. A third possibility, the one worrying attorneys the most, is that Congress is attempting to create a two-tiered permanent residency system where compliance determines rights. But today, advocacy groups took that card off the table. They didn't wait for implementation. They didn't rely on future Congresses to fix current problems. They didn't hope that courts would eventually intervene. They filed immediately, strategically, and comprehensively. What we're watching now is a test of resolve. Congress wants to see whether immigrant communities will comply quietly. Green card holders want to show that permanent residency means something. Courts want to prevent constitutional overreach while respecting legislative authority. And the American public wants to understand what kind of country we're becoming. The answer to all of these questions will emerge over the coming months. But tonight's response suggests that affected communities are not willing to accept these changes without a fight. Tonight, we've heard from immigration attorneys who are now tracking every legal development in real time. They say the first temporary restraining order motion will be heard within 72 hours. They say multiple federal circuits are prepared to issue conflicting rulings, accelerating Supreme Court review. And they say Congress's decision to make provisions retroactive is likely part of a broader strategy intended to maximize compliance before legal challenges conclude. But green card holders are not retreating. In fact, affected communities are mobilizing at unprecedented levels. Their response today, unified, strategic, and determined, sent a message to Congress that legislative aggression will be met with legal resistance. And it sent a message to the courts that constitutional principles remain worth defending. As the week goes on, we expect more details to emerge about what exactly Congress hoped to achieve with this legislation. But what we do know is that today's legal response was timely. It established constitutional challenges before implementation begins. It unified fragmented advocacy communities under common cause. And it demonstrated that 13 million green card holders are not voiceless. What happens next will depend on what Congress does in the next legislative session. If they negotiate in good faith, this moment will be remembered as a turning point toward genuine reform. If they double down on enforcement, advocacy groups have already shown they are prepared for prolonged legal battle. They have shown they are ready to respond. And tonight, for the first time in decades, Congress appears to be reconsidering. Capitol Hill is quiet. Too quiet. And when lawmakers are quiet, it means they are watching. It means they are choosing their next move carefully. Because tonight, Congress learned something they have learned many times before. Immigrant communities are resilient. Legal advocates are prepared. And permanent residents will not accept the erosion of permanence without resistance. This story is far from over. But tonight, one thing is clear. Green card holders are awake. Their advocates are mobilized. And 2026 will not unfold the way Congress expected, and we will be here, watching every detail as the next phase unfolds.